The second case on this morning's docket. That is case number 101624, State of Kansas v. Myoun, Sawyer.
Your Honors, I'm Reed Nelson, and I'd like to request 3 minutes for rebuttal.
3 minutes is granted.
And this case comes to you on petition for review from the Court of Appeals. And this was a conviction in Wyandotte County for criminal threat, for which the defendant was sentenced to 16 months with the Department of Corrections. I raised three issues in the brief, and those are included in the petition for review for you. I will spend my time today talking about one of the issues, which is the failure of the trial judge to recuse himself or be recused. And of course, I will take questions on any of the other two issues. Essentially, the defendant filed an affidavit requesting that Judge McNally recuse himself from the case. Judge McNally had an informal hearing on that, ruled against the defendant. That went to the administrative judge, who also ruled against the defendant. It's went through the Court of Appeals. Now you have it. Your review on this question, I believe, is unlimited. So you are able to take a look at the affidavit the defendant filed and make a decision as if you were the administrative judge in Wyandotte County looking at this. The affidavit listed about three grounds asking the judge to step down from the case. And they were based on prior dealings between the defendant and Judge McNally. Prior cases. One, Judge McNally apparently had him bound and gagged during sentencing. Number two, the defendant had filed a civil lawsuit against Judge McNally. And number three, based on prior communications between Judge McNally and the defendant, Judge McNally had recused himself from a bench trial. So that's what the affidavit was. To my knowledge, that has not ever been challenged by the prosecution, the truth of that. And I think at this point, we essentially accept the truth of that affidavit and look to see whether it's legally sufficient and whether legally the judge should have recused himself based on those allegations.
Does the record clarify that the civil suit was against or filed by Mr. Sawyer? There's plenty of references that there was a pending civil suit against Judge McNally, but I wasn't clear that it specified that defendant was the plaintiff.
Right. It did not clarify that in his affidavit. He doesn't say that he doesn't say literally, I filed a suit against Judge McNally, I don't think. But in the context of an affidavit where he is requesting the judge to be recused, in the context of these other allegations, I think that is presumed that he filed a lawsuit against Judge McNally. I mean, why else would he have put it in there? It wouldn't make a great deal of sense.
Assuming that he did file it, is there something special about the lawsuit that speaks to recusal, or is it just the fact that a lawsuit was filed?
I think the fact of a civil lawsuit being filed against a judge that you are now in front of is a classic conflict of interest for a judge. Certainly is for a lawyer. I don't think that we hesitate very long. If there is a lawsuit, by a client filed against us, we generally move to get out of that case.
Then what prevents every criminal defendant who's been convicted of filing a civil lawsuit on their own between conviction and sentencing and getting a different judge?
Well, if it's
just the fact of the suit, then hasn't that rule eliminated every judge?
If they are attuned to that idea that they're able to do this, then nothing does. Nothing prevents anybody from doing anything like that. But But the court, and I'll refer to the U.S. Supreme Court decision in Caperton, which I know you're all familiar with, the court in Caperton faced the exact same kind of issue. They wondered, well, if we reverse on this, where litigants appear in front of this Supreme Court, and there's a financial interest at stake.
Caperton had a different set of facts because it was a $3 million or whatever it was campaign payment to the Supreme Court justice that was involved. This is simply the filing of, I'm only asking about the filing of a prisoner lawsuit that eliminates every sentencing judge. Because Caperton's not going to come into play with that set of facts.
Right. So let's just take a hypothetical. Somebody files the lawsuit like they did in this case, alleging it's a civil lawsuit, saying that the judge is the defendant in the case. Then there can be a hearing on that where the judge or the prosecution says, you know what, there's been a lawsuit filed against me, but that doesn't matter because, number one, it's frivolous. Number two, this is the third one from this defendant. So in other words, there are facts surrounding those types of lawsuits that can be brought to light to show that this lawsuit should not affect the judge staying on the case or not.
So what is it about the filing of this lawsuit that shows us that Judge McNally shouldn't have stayed on the case?
Well, I think that there is a presumption that when a lawsuit is filed against somebody, the very definition of bias is that there is ill will. And if somebody has filed a lawsuit against me, it's highly likely that I will feel some level of ill will against that person.
So the frivolous nature of the lawsuit doesn't matter because it's the act of filing that creates the ill will.
Well, I think that if it's clearly frivolous, I think that a judge is very willing to disregard that and not be affected by that. If the judge recognizes, look, this person is striking out in frustration, it looks like this person is forum shopping, then the judge can make a record of that, and that goes to this court, and you can make a reasoned determination. Yeah, that is supported. It looks like this defendant was just forum shopping. There's no indication of that in this case.
But what Caperton instructs us is that determination is an objective determination. We wouldn't look at whether the frivolous nature would change the mind of this particular judge. It's a objective determination of whether it would give the appearance of a conflict. Isn't that what Caperton really teaches us? That the determination of whether that campaign contribution created a conflict was not whether the particular recipient would feel obligated or would feel compelled to rule in that donor's favor, but whether objectively people would look at it from the standpoint that it creates the appearance of conflict. Isn't that really what Caperton's telling us?
I think that is correct, that Caperton, in my view, the Caperton court looked at this and said, this looks like a classic conflict of interest, and we're not going to get into the mind of the trial judge.
That's what I was trying to ask you. So here we wouldn't get into the mind of Judge McNally as to whether this lawsuit really would change his mind one way or another. It's whether it would appear to create.
That's correct. You wouldn't get into the judge's mind, but I think, and I think it has to, frankly, be this way, that if it were developed at the trial court level, you could. In other words, I don't think that at the trial court level everybody is just stuck with the fact that a lawsuit has been filed. I think if the prosecution or the trial judge is interested in getting behind those facts and contesting them, that could happen.
We've had a number of judges look at this issue You recited to us, it first went to Judge McNally, he denied it, and then went to his chief judge, that was denied, then went to the Court of Appeals where it was denied. So are you saying that none of these people were looking on an objective basis for the probability of actual bias?
Here is where I think that they went wrong. The administrative judge and the Court of Appeals, Judge Lieben wrote the opinion. Where they went wrong was they drew a distinction between a judge who is the trier of fact. They said, yeah, he properly recused himself from the bench trial, but this is a different question because he is not a trier of fact anymore. He's going to be presiding over the evidence, the admissibility of the evidence during this trial. And I have not seen a case, I haven't been exhaustive about it, but I haven't seen a case, and certainly the statute doesn't make that distinction between the judge's roles. And in fact, in Caperton, the judge wasn't acting as a fact finder in Caperton, and they found a high probability of bias. So I don't see the distinction. Judge Lieben drew that distinction. The trial judge drew that distinction. He said, I recused myself previously from the bench trial because I was going to be a trier of fact, but now my role has changed. And I just don't see the distinction. Bias doesn't turn on and off for somebody depending on the nature of the proceeding.
Judge McNally the sentencing judge?
I think so. I don't know that for sure. I'm assuming he was. And
your affidavit, the affidavit on the motion for change of judge doesn't mention anything about that prior recusal. That's mentioned in your motion or in the motion below, but there's no support for it in the affidavit. And then there's a brief discussion in the transcript where the judge says, yes, I did recuse before, and I thought I needed to, but I don't need to now because it's a bench trial, or it's a jury trial versus a bench trial. Is there anything, it appears to me there's nothing in the record that tells us what happened that caused him to recuse before or to think that he needed to recuse, and I wonder if you can add to that.
right, I don't see that either because they just talked about past communications. So I don't know if it's the result of him, this whole gag order thing.
Right.
And no, it is not clear. It is not clear to me.
You don't cite to it, but there's a Court of Appeals case, a separate case, State v. Sawyer, the Court of Appeals ruled on prior to this case that Judge McNally was also the trial judge. Are you aware of that? The Court of Appeals specifically talked about Judge McNally's comments to this defendant.
Is that a federal case or is that here?
No, it's a Court of Appeals case.
Oh, no, I'm not aware of the one here.
Okay.
No.
In 2009.
I read Judge Lieben's.
And it appears that was a jury trial. So I'm a little confused. In that case, that was a jury trial. And so I guess it appears that Judge McNally sat on that jury trial, so maybe he made a ruling in that case previously that he didn't need to recuse. I'm just wondering, was a motion to recuse made in that case? Because it appears to be after the case that started this whole deal, the bench trial.
I don't know anything about that case. I'm sorry.
Okay. Just wondering.
Yeah, I don't.
Any further questions of counsel? Thank you, counsel.
Thank you.
Good morning. Again, I'm Jennifer Tatum, an assistant district attorney from Wyandotte County. On behalf of the appellee, I will follow suit and just discuss issue 2 unless you have questions about issue 1 or 3.
Are you aware of the other case?
I am aware of the other cases. I believe that
You were the attorney of record, weren't you, in that other appeal, in the Court of Appeals?
I was the attorney of record on the brief, yes. I
Right.
did not do the trial myself, but because of writing the brief,
Right,
I'm
you're aware of it. Mm-hmm.
Right, and that was a case. He was charged with multiple counts of lewd and lascivious behavior, I believe.
Based on his conduct in jail,
Yes.
like this case, yeah.
Yes, and I believe and I know this is not on the record in this case, but I believe the other case that Judge McNally recused himself in was a similar case where it was sexual misconduct in the jail. And I believe that had some things to do with the defendant's credibility, and the judge may or may not have been able to fairly judge his credibility after hearing the evidence of several incidents in the jail. This is obviously very different from that because it did not involve, well, first of all, he wasn't hearing the case as the trier of fact. It also didn't involve...
Stop right there.
No.
Stop right there. If this case stands for anything but that proposition, I'm having a real problem with distinguishing between the role of the judge as trier of fact and the overall role of the trial judge in overseeing that justice is done. How can someone who acknowledges that I might have a problem if I were trier of fact make any kind of unbiased discretionary call that starts right at the outset of a jury trial? Whether a juror gets removed for cause is a discretionary call. Many of the evidentiary hearings that are objections that are made are discretionary calls, or even if they're not discretionary calls, how can you draw that line that there's a difference? I read that at the outset, and I'm having a real problem if that's the standard, that you can distinguish that it's different if I'm a trier of fact versus that I make discretionary calls, or if I'm overseeing the entire process of the trial. Don't you have to be fair and unbiased regardless of what your role is?
I think you do have to be fair and unbiased, but I think the distinction is if you're making a ruling on a legal matter, whether to excuse a juror, whether a piece of evidence comes in, things like that, that's a pretty, I guess, dispassionate determination. You're applying rules of evidence that have been developed over time. You're not faced with a situation where, say, you have a deputy's testimony against the defendant's testimony in a case over whether he masturbated in front of this person, which was what the other case was about.
You're talking about the second case now?
The first case, the 2009 case you referenced. I'm trying to draw a distinction.
All right. What was the case in which he actually recused? It wasn't that case. It was a bench trial.
I believe
sometime prior.
Yes, and I believe it was another lewd and lascivious behavior case. I was not involved in the case he recused himself from, but that's the best of my recollection.
And so after the bench trial that he recused from, Judge McNally then sat on the jury trial in this 2009 case.
My recollection was it was in reverse order. So I apologize if I'm wrong on that. I don't mean to deliberately mislead the court, but I believe they were both lewd and lascivious behavior cases.
Wouldn't that be important for us to know when, in the briefing process in this case?
I think it could be important for you to know. I don't think, as the appellee, it's a burden on us to present that information to you because overall it's an objective determination you guys are making under Caperton based on the facts that you have. And I don't believe it's our burden to give you the facts.
The reason that he recused in a prior case and then perhaps sat on a jury trial, that's not relevant to our determination about this case?
I believe it is, but you also have the facts in front of you that Judge McNally gave, which basically he explained why he recused himself in a prior case and not the case that's in front of you.
We don't have anything about that in-between case that in the Court of Appeals where he must have sat on the jury trial
And again,
in a similar type of charge.
I think,
Again, conduct in the jail.
I think that the burden is on the appellant to provide that information to you if they wish that it be considered, and that information wasn't provided to you by them. I don't know all of the information relevant to that. What I can tell you is that in this case, based on the record in this case, if you look at it, there's no instances where Judge McNally demonstrated actual bias. They've pointed to no objections that were overruled, no evidence. They tried to admit...
But that prior case would be some instances, wouldn't it? I think in that prior case there was, like, the judge told Sawyer to shut up or something like that, and the panel of the Court of Appeals simply reminded the judge of the Code of Judicial Conduct. Those are specific acts that would factor in to an objective determination. If you had a judge that had done this in the past and been admonished, what obligation is there upon that judge to recuse in the next one? Don't you think that has to be a factor?
I think it can be a factor, but I don't think first of all, Mr. Sawyer didn't include that factor in his motion, which the statute commands him to do, is to create a clear affidavit, submit it to Judge McNally, also follow through with that to the Chief Judge, and finally create a record for you, a clear record to decide upon, and that wasn't done in this case. He made very bare bones allegations, didn't cite anything specific about Judge McNally's behavior, and Judge McNally certainly didn't exhibit any of that type of behavior in this case. Mr. Sawyer wasn't bound and gagged. There was no, Judge McNally never was rude or disrespectful to him. A review of the record will show that. In addition, he was the sentencing judge. He had the opportunity to choose any three in the box. I think Mr. Sawyer asked for the mitigated number, and he went with the standard number, which is standard. And when there's no mitigating or aggravating circumstances, obviously that shows he was treating Mr. Sawyer as he would anyone else.
But part of the problem I'm having is that at the time that decision for recusal faced Judge McNally, he didn't know what those decisions were going to be. There could have been a motion for departure filed by Mr. Sawyer, where Judge McNally would have had to make findings of fact. So doesn't that go against the rationale of his decision that he wasn't a fact finder? How could he know that throughout the proceeding there wouldn't be even a motion to suppress? I mean, something along the way that would have required him to weigh the credibility of Mr. Sawyer.
Well, I think, Mr. Sawyer waited quite a while before he filed his motion. I think it was like 4 or 5 months into the case rather than the first 7 days as the statute commands. And at that point, I think Judge McNally, as well as all the parties, had a good idea what motions were going to be filed or which were not, and the general nature of the case. And so I think he did have some of that information available to him and was able to make a reasoned decision. But I also think if something came up, during the course of the trial, and he felt that he couldn't be impartial, he was free to say that, whether it be at any point during the trial or at sentencing.
Free to just declare a mistrial and start over with a new judge in the middle of the trial.
I think it would have been very inconvenient, but I think he could have, and I think he would have if he felt that were the case. This particular case, it didn't really involve complex issues of law. It was, or fact even. I mean, it was a person who was working as a commissary lady in the jail. It involved limited witnesses, just testimony of people who were there. And the jurors were required to see whether they believed Mr. Sawyer threatened this woman or not. Even Mr. Sawyer himself said he called her a bitch and he was upset. He felt like they had mismanaged his money. And that's all it came down to. Judge McNally wasn't called upon to make any decisions regarding suppression or anything that would be considered a complex issue of law, really.
Were there any motions for continuance of trial?
I don't believe there were in this case. I believe Mr. Sawyer had cited to a motion in a prior case where a motion for continuance was denied. But I don't believe that happened in this particular case.
To go back to Justice Rosen's request, and we had a number of people kind of cut in on him. Did you finish your question, Justice Rosen?
I finished the question, but I don't think I got an answer. And even just your answer here, you seem to make a distinction between making credibility determinations based on facts that are presented as opposed to any other evidentiary ruling. And if you can't be impartial on one, or there's a question about that and the judge acknowledges there is a question about that in one area, how that doesn't, how you can separate and parse that out to other important critical roles that the judge plays in the proceeding. You haven't convinced me yet that that's the case, and you did get cut off on your answer. So, is there anything you can tell me that there's a difference?
Well, I think I'd probably be repetitive from what I was telling you earlier, but I think it is very different if you're making a rule on the admission of evidence or whether or not to excuse a juror, or being in the position that our jurors were in this case, which is, do we believe Miss what was her name, Valdreau, that she felt threatened, or do we believe Mr. Sawyer, who just said, I was just calling her a bitch, and it was because
I guess basically what you're saying, that if in my role as a trial judge, if I had a problem with a particular defendant, and it comes up here on an appeal because it's clearly just a legal question, I wouldn't have to recuse.
I don't.
I mean, it's a little different because I would be reviewing my own decisions, but that's the point. Is that once you have a conflict, don't you have a conflict?
I don't necessarily think so. If you are dealing with an issue of credibility, I don't, and I guess my argument's probably not very persuasive. But if he has to decide whether or not a piece of evidence comes in, there's plenty of case law about that. You're not deciding whether you like the defendant or not. You're just applying a principle of law, basically.
What if it's a Jackson v. Deno hearing on the defendant's confession? You're kind of looking at some credibility there. You make a determination, and if the confession comes into evidence, the jury says, hey, the guy confessed, he's guilty. In your view, the trial judge in that instance says, hey, there's no bias here. There's no need for me to be recused.
Well, I think that would be a much closer call, because in the Jackson and Deno hearing itself, I'm sure the defendant might testify and say I was coerced or this pressure was applied to me, and then the judge would be making sort of a credibility decision. And so I think that's a closer call. In this case, that didn't happen. It was.
Or even I'm just going to say, even a piece of what I call ordinary evidence that's admitted, and then we review that for an abuse of discretion. I don't want to say we always say that there's no abuse, but that makes a much tougher call for us. And if there's any bias in the judge's ruling, it'd be hard for us to find.
But in this case, there weren't many exhibits, but one of the exhibits was a videotape from the jail and of the incident. And the foundation was laid through someone at the jail who testified that the system was recording properly, things like that. So the standard foundation requirements, that's what he had to rule on. I think it was even introduced without objection. A
ruling by a judge that, I'm sorry, that is just too remote in time, I'm not going to allow it to be admitted, and it's the defense request for the admission, that's a purely discretionary call, isn't it?
It could be, but those things did not happen in this case. And I think that's why we go back to trusting that the trial judge will act impartially and giving him that credit, that he's the best judge of that, and he knew things about this case, and the trial proceeded, and there weren't issues like that in this. Sorry.
I'm sorry, I didn't mean to interrupt. How does our standard of review work with that? If we were to apply a objective standard at the point in time when the judge ruled, and we were to determine that from an objective standpoint, Judge McNally should have recused, then do we look at these arguments you were making to say that his error in not recusing was harmless? Or is this an issue that can't be cured? That we don't do a harmlessness analysis?
I think that you could do harmless error analysis on this. Obviously, it wasn't argued in the briefs, but when it went to Court of Appeals, Judge Lieben cited Caperton and added that in, and we didn't argue that further, but I think that it can be a harmless error analysis under the facts of this case, because we do have the facts, and there was no actual bias shown in his rulings. So I would think that would cure it, even if you're going to presume there was some bias on his part. When you actually look at the record, there's not any bias shown towards Mr. Sawyer in this particular case. So I think that would cure it.
Before you go on, counsel, I think I cut Justice Johnson off on a prior question. Do you still have that question?
No, but I do want to follow up on that. How does your answer dovetail with Caperton? Because Caperton said we don't really need to look at whether that justice was impacted on determining the appeal. We look at the fact that there was a $3 million contribution objectively sets up the classic conflict of interest. So that instructs me that harmlessness based on the subsequent performance of the judge doesn't cure it.
Oh, I think this is a very different circumstance from Caperton because, and I don't know all of the facts cold from that case, but I think the amount of money that was spent by a party on that person's campaign easily allowed the court to say this judge should have recused himself. I think in this case, it's just not nearly that clear. But I think that also when you have the benefit, and I don't know if they had this in Caperton or not, I guess they did. They had a ruling. But in this case, you have the record, and there's just no instance of any wrongdoing by this judge. Whereas in Caperton, it was a little bit more egregious. Isn't
this really a stronger case since we have this judge recognizing that he can't be impartial in a prior case? That's a little different situation. And so it really all comes down to whether this distinction that he makes later, which is, yeah, I decided I couldn't be impartial in the prior case, but that was a jury trial, or that was a bench trial, now this is a jury trial, is a valid distinction, isn't it?
I don't think it is because in this case, Judge McNally didn't have one of the parties contributing that much money to him. He didn't have that pressure.
No, but he's recognized that he can't be impartial in a case involving this defendant.
But he knew the jurors were going to be making that decision of guilt or innocence, not him.
Well, I'm just saying, doesn't it all kind of come down to whether that's a valid distinction to be made?
Because in Caperton, there was no acknowledgement by the justice on the court that there was a problem.
Right. Well, that is a difference in this case, obviously, but also in this case, you have the full record, and there is no actual
Well,
bias.
we don't
In
really have
Caperton,
the full record. We don't really know what happened in the prior proceeding that caused him to decide he couldn't be impartial. We don't have the full record as far as what happened in between in the second case where he must have made a decision in that case as well to sit on it.
But and what I would say about that is I think the burden is on
I
the
understand.
defendant
I'm
at
just
this
saying
point.
I don't think we really do have the whole picture here.
Well, we may not have the picture of what happened in the past, but we know exactly what happened during this trial, and those are the facts we're stuck with. And he just did not do anything that would suggest he was biased against Mr. Sawyer during the course of this trial. He just didn't. So I don't know how to.
He did recognize, however, that he'd previously decided he couldn't be impartial, but
Yes.
made the distinction that that was a bench or a jury trial
He said in a case where he was the one who had to determine guilt or innocence, he did not know.
or a bench trial. Yeah,
Right,
Sorry.
if he
Yeah.
could be impartial. But in this case, the jurors were the ones who determined guilt or innocence. As far as any rulings on sentencing or motions or evidentiary issues, they pointed to nothing that would indicate bias. And I know I'm out of time, but I'd also add, I meant to add this earlier, with regards to the case that was allegedly filed against Judge McNally. Judge Lieben did a little of the legwork on that, searched the database, and said there is no such case in his opinion. So I think we can rely on that there was no case that Mr. Sawyer ever filed against Judge McNally. I think the last case
We can take a Court of Appeals judge doing some fact-finding here and take that as the record.
Well, he did it as part of his opinion, and I would think his opinion would be, he did that with regard to some of the factors, and I think that would be persuasive to you. So,
Any further questions of counsel? We took an awful lot of your allotted time. Would you like 30 seconds to wrap up?
Sure. Thank you, Your Honor. I appreciate that. What I would say is I would urge you not to find, this is not a case like Caperton or the cases they discussed where you should find actual prejudice. It just doesn't rise to that level. Or I'm sorry, not actual prejudice, but presumed prejudice. It just does not rise to that level. And if you can't do that, then you go back to the other test where there has to be actual prejudice demonstrated, and there wasn't in this case. We would urge you to uphold the conviction. Thank you.
Thank you, counsel. You reserve 3 minutes for rebuttal.
Addressing first the question of harmless error, I don't I don't think we addressed that in the briefs. I think it would be fairly strange, though, to find that on the one hand a judge was biased in handling of a trial, but on the other hand, that is somehow harmless. It seems to me that a defendant has a right to an unbiased judge at trial. Number two, if harmless error were to apply to this specific case, there, number one, were decisions that were either wholly or almost wholly discretionary with this judge. For example, the consecutive sentencing is something that this court certainly can't review, and that's a wholly discretionary decision by the judge. And there were evidentiary matters that, while not totally bulletproof from review, are almost bulletproof and lie within the judge's discretion. The finding was made by Judge McNally and even the Court of Appeals on bias, that he had been previously too biased to do the bench trial. And so that was made, and nothing really changes that.
What's the time sequence here, do you know, between that finding and then his motion or his ruling on the recusal, in terms of when he determined that he couldn't hear the prior case and this case, you know?
Right, when he determined he couldn't hear that bench trial.
Yeah, the lapse of time between the two.
I don't know.
Okay.
Yeah, I do not know. If there are no other questions for me, I'll sit down.
Any further questions of counsel? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. This time the court is in recess for 15 minutes.